How are the decisions made for an incapacitated person without a living will? So this is question number 3. If you're incapacitated and you don't have a healthcare directive or a living will, and you don't have an estate plan whatsoever, here's what the world looks like. First, if you end up in a hospital and you're incapacitated, what does that mean? That means you can't make decisions for you. Someone else has to make decisions for yourself. But you haven't written down what you want those decisions to be, who you want to be in charge, how you want your body to be treated when you can't speak for yourself. That's a very dangerous position to be in, because guess what? The law doesn't just assume who gets to take care of you. In fact, when you're in a hospital, it's whoever cares about you. Your spouse, your children, your brothers and sisters, your next door neighbors. As long as they all care about you, they all get to make decisions for you. The doctors aren't the ones that are allowed to pick and choose who gets to make decisions. So if it's just your spouse at the hospital, they'll make decisions for you. If it's your spouse and someone else at the hospital, they make decisions as a group. And you know how dangerous that can be, because there's going to be so many arguments on what's the right thing to do. And the moment there are arguments where the doctors have to look left and right and try to figure out what they're supposed to do for you, they're going to say, go to court and have a judge appoint a conservator or guardian. A guardian, someone who is in control of your body, right? And the moment that the judge appoints someone, it becomes infinitely more difficult for that someone to be removed as your guardian. So let's say you regain capacity, you then have to go to a judge and say, Judge, I regained capacity. Tell this person their job is done. And that person will have control over your body and your medical decisions, even when you have capacity, until the judge removes them from that position. It's not automatic. So this is so simple. Just create a simple healthcare directive or a living will. These are 2 legal documents, a little different in how they work, but they're essentially the same, where you are saying, this is the person who will make decisions for me when I'm incapacitated, and these are the kind of decisions they can make for me, and this is how I want to be treated, giving them a little bit of instructions on your insights on what you want. Why is that so important? Because remember, when you're incapacitated, you can't make choices for yourself. You can't speak for yourself. So who gets to speak for you? You can decide that now, or you can wait until you do become incapacitated, and the world will decide for you, and you will have no choice on the outcome. Now let's talk about money. More importantly, if you're incapacitated and you're the only one that has access to your bank accounts, nobody will be able to touch your money. That's a good thing, right? That's how we protect you. Well, who's going to pay your bills? Who's going to pay your mortgage? Who's going to help pay for your kids' college tuition or loans, whatever gifts you give to your children throughout life? Nobody will have access to your money. The only way you can give someone access to your money is either you create a power of attorney, a financial power of attorney that authorizes someone to act as your agent to be able to handle your finances for you when you can't. And we can even limit your power of attorney so that it's only effective when you're incapacitated. That way no one can abuse that power. Just like the healthcare directives, like we said, with medical decisions, this is for someone making financial decisions. If you don't have a power of attorney, then the only other way that people can make financial decisions for you is through a trust that you set up for yourself, and you move all your assets into the trust. Like I said before, a trust is a will substitute, but it is also a power of attorney substitute. A trust protects you during life and at death. A will only protects you at death. A power of attorney protects you at life. 2 documents that you can have with one that gives you a huge layer of extra protections that we don't have enough time to go into, but I would love to have a chat with you more about that if you have questions. But if you don't have any legal documents in place, then where do we go? We go to court. We have to get a judge to appoint someone as your financial conservator. Let me tell you how much more dangerous it is to have someone appointed as your financial conservator. Because again, the moment you regain capacity, they haven't been removed from their powerful position, and they can do so much with your money even while you are alive and have the capacity to do your own things with your money. You won't have that power yourself. They can take over your bank accounts and push you out. I want everyone to look at what's happening with Britney Spears right now. She has a financial conservator. It is her father or her father's lawyers, and they have full control of all her money. She has no say on how she handles her money even though she's seemingly, in my eyes and the eyes of a lot of people around the world, a sane person, a healthy mother, someone who's running a very valuable business, who's living a very fruitful life, raising 2 kids. So there's some risk with that. And to remove a financial conservator from their power, you have to go back to the judge, prove to the judge that you have capacity and that you are not just alive and well, but you have the power to handle your own affairs yourself. It's a higher burden and not very easy to do. Conservatorships are very hard to get out of right once you're put into one. They made a whole movie that won an Academy Award on this called, I forgot what it's called, but you can Google it and find out. I'm so sorry. Oh, I Care a Lot. There we go. I had a whole blog article on this. So that's something to think about. If you don't want to have a guardian appointed to you or a financial conservator appointed to you by a judge, a total stranger who doesn't know who you are, doesn't know what your wishes are, and they'll most likely choose lawyers to do it, not your family and friends, because they don't know who they are too, then you should put an estate plan in place. You should get a trust. You should get a power of attorney. You should get a healthcare directive. You should put your will together. I don't like to just tell people to do one document. I say be comprehensive so that you have plenty of safety netting as well as plenty of protection around you. If you have questions about this, I'm more happy to answer them for you.